Okay, welcome everybody to the monthly World Court of Human Rights Coalition meeting where we talk about the creation of a future World Court of Human and Environmental Rights, the court that doesn't yet exist, but we know that it should to help deal with the many, especially gross violations of human rights that are continuing around the world. My name is David Gallup. I'm also here with, I'm the convener of the coalition. I'm also here with Mark Ottinger, who is the head of our World Court of Human Rights design team that helped draft one of the draft statutes for a World Court of Human Rights, as well as others who are involved with us, like Dr. Chobo and Anuj Chawla, who I'll be talking with later this week to be working maybe as a government outreach coordinator for India with us. So some of you are lawyers, some of you are not, but we'll make sure to, if there's any things that you don't understand, raise your hand and we'll deal with that. But we're here today with Alyn Ware, who I will introduce momentarily, and he's our expert guest speaker. So thank you, Alyn, for being with us. First, though, I would like to say anyone who wants to introduce yourselves, which some of you already have in the chat, just for time's sake, please feel to give your name, your affiliation, or organizational representation in the chat, and feel free to talk to each other during the meeting. So I appreciate that. So just a brief update for the World Court of Human Rights Coalition. I'm excited to announce, although I should temper my excitement because it's not final yet, but I was just looking at our petition to the NGO branch of the Economic and Social Council of the UN that says that our petition to become, have consultative status and being able to interact with the UN, the third and sixth committees, and go to UN events in New York and have those UN passes will hopefully come through sooner than I thought, because I thought it wasn't going to be until June of 2025. But our application has been reviewed and has been submitted for clearance. So hopefully that's the last step. Some officer has to just look at the thing and sign off on it. I hope that will be it. So maybe at our next meeting or in the next few, I'll be able to announce that. So thank you for that. We are still seeking some additional individuals around the world in different parts of the world who will be our government and organizational outreach managers for particular regions of the world. We do have a woman named Wanyaka who's in Kenya, who is our social media coordinator. There's also a government outreach coordinator who also happens to be from Kenya for Africa, but we can have more than one person for each region of the world. So if you know of any students or people, young people, or any people of any age who have spare time to give to us as volunteers in particular, because we don't have paid, none of us are paid staff for the World Court of Human Rights Coalition, who are interested in supporting this idea of creating a World Court of Human and Environmental Rights, please give them my email. I'll put my direct email in the chat here so that you can have them email me their interest in participating in one way or another with our coalition. So I would appreciate that. Thank you for that. So now let me introduce our special guest expert today, Alyn Ware. Alyn is a peace educator and international peace and disarmament campaigner. Alyn is currently program director of the World Federalist Movement, co-founder and global coordinator of Parliamentarians for Nuclear Non-Proliferation and Disarmament, peace and disarmament programs director for the World Future Council, and you can see he has World Future Council listed on his name for Zoom purposes. He's director of the Basel Peace Office and international representative of the Aotearoa Lawyers for Peace, which is part of the International Association of Lawyers Against Nuclear Arms. He previously served as executive director of the Lawyers Committee on Nuclear Policy and as founder director of the Mobile Peace Van Schools Outreach Program in New Zealand. Alyn is one of the leaders of the successful campaigns to prohibit nuclear weapons from New Zealand in the 1980s, and that's sort of where we'll start our conversation today about that, and to achieve a ruling from the International Court of Justice, the ICJ, on the illegality of the threat and use of nuclear weapons in 1996. He has co-founded other international peace projects and networks, including Abolition 2000, Middle Powers Initiative, Move the Nuclear Weapons Money, Unfold Zero, and No First Use Global. I first met Alyn, and maybe he remembers this, back in the early 1990s at the International Peace Bureau when he was on the board of the IPB in Geneva, when he was working on the World Court project regarding the threat or use of nuclear weapons. And I've caught up with Alyn multiple times and occasions over the years, such as at the largest World Peace Conference ever, which was the 1999 Hague Appeal for Peace Conference, and more recently in New York at the Week for World Parliament, and even here in Washington, D.C., where we, as well as the local branch of World Federalist Movement, Citizens for Global Solutions, has their headquarters here in D.C. For prep meetings for the Law Not War campaign, Legal Alternatives to War campaign, which I'm sure Alyn will tell us a little bit about today. And in addition to his New Zealand citizenship, he also has a world passport. So yay, thank you for that, Alyn. He's a world passport. There it is. He's a world passport holder. So I want to thank Alyn for sharing his international law and coalition advocacy with us today. I'm sincerely delighted that you're here with us. And now I'm going to stop talking. And Alyn, I guess I'll start with the first question, though, to start you off, but you can say whatever you want. We're not here to control what you say. You can say anything you want. But I'd love to have you tell us about how you really got involved, in peace education and in eventually in nuclear disarmament. I mean, even as early as, I think, even before you were a teenager. So please, we'd love to hear from you.
Yeah, well, thanks, Dave, and thanks so much for the invitation. And just to let people know that I'm joining you today from Prague in the Czech Republic, which is where I've been based for, I think, the past 6 or 7 years now. I have lived in the United States, in New York, for about 10 years. I'm originally from New Zealand. So I've had the privilege of being able to experience living in different countries where you see different influences, and all these have been like really great experiences. Just to let you know that Prague is also where the first woman to receive the Nobel Peace Prize was born, Berta von Suttner. And David, in the introduction, you mentioned the Hague Appeal for Peace Conference in 1999, when 10,000 people from around the world came to The Hague, basically in follow-up to the first 2 Hague Peace Conferences, which were government ones. And Berta von Suttner played a really instrumental role in the first 2, the government conferences, which is why she got the Nobel Peace Prize. And then it was up to civil society to take over and elevate, the ideas of banning war, of bringing in international legal approaches to resolving conflicts rather than war. And this is all part of this context of us sort of elevating the idea of law, not war, legal alternatives to war, which I'll talk about in a moment. But that's where I am now. But yeah, I come from New Zealand, and in New Zealand, my first career was in education. I got into law a little bit later. And as a teacher, feeling that you can't just teach children how to do reading, writing, arithmetic, skills like that. You have to actually help ensure that there's a safe environment for youth to grow up in, and nuclear weapons were threatening that. So as well as being a teacher, I became very much involved in the campaign to ban nuclear weapons from our country. We were part of an alliance with the United States. It was called ANZUS, Australia, New Zealand, and the US. From my perspective, the idea of, during the Cold War, of welcoming, which our government did, nuclear weapons into our harbors, to me, that didn't seem like protection. It seemed like it'd make us a target. It seemed like it'd make us sort of like a threat, in any conflict. And wouldn't be better if instead we took, a neutral peacemaking role. So our campaign, for banning the nuclear weapons in New Zealand wasn't just about banning the nuclear weapons. It was about New Zealand playing a more of a positive role in the international framework, particularly the United Nations, to be able to resolve conflicts and build security without relying on the threat or use of force, of which nuclear weapons is the ultimate form of that. So our campaign was highlighting the really good work that can happen through the United Nations, whether it's the UN General Assembly, sometimes the Security Council, a lot of flaws there, but also other organs like the Human Rights Council, like the International Court of Justice, like the good offices of the UN Secretary General, which are used very often for mediating conflicts. And the UN Charter itself is a wonderful guide to the ways that we can prevent war. It actually bans war, and the ways that we can resolve these conflicts. In the UN Charter, it says the different approaches you can take: diplomacy, negotiation, mediation, adjudication, and arbitration, which is sort of arbitration and adjudication, which are the different types of courts and tribunals, as one part of the package of common security mechanisms. So that's what we were elevating in New Zealand. And I think that's what helped convince New Zealanders that, oh, we didn't have to rely on nuclear weapons, that there was enough of a system in the UN. It's not perfect. There's problems with it, but there's enough of a system for us to put more of our reliance on that, which is why we're very involved. Now, one of the reasons I think we sort of could push this was because we had good experience from the UN system in conflicts with powerful countries. New Zealand's a very small country. It's 5 million people now. When I was growing up, it was around 3 million. And we had conflicts with some big, powerful countries like France, for example, which was testing nuclear weapons in the Pacific. The UK and the United States did it in the 50s, 60s, but stopped. France was still doing it when I was at high school. We were still testing nuclear weapons into the 70s, into the 80s. And first they were doing it in the atmosphere, which is incredibly destructive. The radiation is traveling over the Pacific, depositing on the islands, horrible impacts from those, from stillbirths of babies, cancers, horrible diseases. And so what New Zealand did, along with like trying political pressure, which wasn't really going very far, civil society was doing protests, of course, but they weren't going very far, was New Zealand lodged a case in the International Court of Justice against France. France sort of said, well, we're not going to listen to the court. Like, we don't have to. The acceptance of the jurisdiction of the court is voluntary, so you can't sort of force a country to accept its jurisdiction. But what happened when we took this case against them on atmospheric testing in 1974, France sort of protested, we're not going to listen to it. But the very next year, France stopped atmospheric testing of nuclear weapons. So what you could see here is that the courts and bringing in law can actually have a very strong influencing factor. Even if it's not enforceable, even if at times it's not binding, it has a really strong influencing factor. We saw that again with France, because that was only stopping the atmospheric testing of nuclear weapons. They then shifted their program underground. So we basically went back to the court in 1995 on a case against underground testing. It took a long time to get the evidence that underground testing was detrimental to the environment, but we got there. Same sort of thing. First, France said, we're not going to listen to the court. The very next year, France stopped all of its testing in the Pacific, closed the nuclear test site, and signed the Comprehensive Test Ban Treaty. So this was just one example of the value of a judicial process, including the International Court of Justice. There are other ones in the Pacific as well. There's a small island in the Pacific called Nauru, and it's one of the places where you have migrating birds, they may migrate long distances, between the seasons. They often stop in some islands in the middle of the Pacific, and there they do their business, which means there's lots of birds dropping. That creates very, very rich soil there. And what Australia and New Zealand have done has actually gone and basically ripped off all the topsoil from Nauru. 90% of the topsoil was taken, by Australia and New Zealand to put on farms in our countries. And poor Nauru was left with it looked like a moonscape. And they didn't really have any way of dealing with this except going to the International Court of Justice. So they took a case to the International Court of Justice against Australia. They won the case. That pushed Australia into compensation, which has now happened. Both Australia and New Zealand given compensation to Nauru, and Nauru has been able to rebuild the topsoil and rebuild their economy too, because this is a resource as well. So these are just a couple of cases that, for me, there are other ones that I was looking at, from the International Court of Justice. There are other ways that the UN was being very effective in helping to resolve conflicts through mediation and negotiation as well. That's what gave me an idea, not as a lawyer, that actually this law is really, really helpful. And so then there was a particular issue that came up that I then got really engaged in. And that was when we managed to convince our government to adopt legislation banning nuclear weapons, our allies did not like it. Our allies, the United States, Australia, France, Canada, the United Kingdom, and they all put pressure on New Zealand. Ronald Reagan did a boycott on New Zealand products. The uh, governor of Queensland over in Australia did the same thing, boycotted New Zealand products because we were being nuclear free. This is really difficult, for our country. And so that's sort of where the idea of taking the issue of nuclear weapons to the International Court of Justice came from. We were going, how do we deal with this? That these powerful countries are punishing us, for just wanting to be nuclear free. We're not telling them what to do. We're not saying you can't have nuclear weapons. We were just saying we don't want them. We don't want to be defended by them. But we were upsetting the whole idea that these nuclear weapons were a force for peace on the side of the West. These are the good nuclear weapons. The bad ones are the Soviet ones. The good ones are the Western ones. And New Zealand was upsetting that by saying, actually, nuclear weapons, we don't like them at all. Doesn't matter who's got them. So it was upsetting that whole framework. So that's why there was this incredible political pressure being put on the country, all sorts. We had the Secret Service agencies, FBI, CIA in the United States, actively trying to overturn the New Zealand government. And there's many stories I could tell about that, which I won't because we don't have time. But the key thing was, here was a dispute we had. Basically a dispute. We believed we could be nuclear free. The United States says, no, you can't. You're part of this military alliance. You have to accept our nuclear weapons. So when you have an international dispute, again, International Court of Justice. So in this case, what we were looking at was not a contentious case against the United States or against the UK, but rather looking at the illegality of nuclear weapons themselves. And that we got the idea from an American, a fantastic American law, professor of law, and the proposal was you take a case through the advisory opinion process for the International Court of Justice. And that process means that you're not saying that one country is wrong over this. What you're saying is that this is what the law is on nuclear weapons. And so that led to that sort of groundbreaking case, on the illegality or threat or use of nuclear weapons. That's how I got involved in the International Court of Justice, because I was basically sent over to New York to run the campaign to get the UN General Assembly to take this case to the International Court of Justice and then bring in enough countries to make sure that we succeeded in the case. So I wasn't a lawyer, but I was coming and seeing the importance of law, how that would really, really help. And then there's political process to get something through the UN and into the International Court of Justice. And then I could bring in all the lawyers, to argue the case, to say, this is the law that applies to nuclear weapons. This is the law. And just make sure that we got all of that into the court, which we did. And as I said, it was a very successful case coming out of that. So that's a bit of the background about why now I'm also interested in other judicial processes, in the role of courts in particular, which is why here we're talking today about World Court for Human Rights, because I have seen how these courts can be so useful in not just resolving conflicts, but ensuring justice, ensuring the implementation of law, and pulling into account powerful figures who without law can sort of do what they want. With law, that restricts them considerably. And so these are assets for us, the international legal processes, and they're not complete, which is where, the World Court of Human Rights comes into play, because we have an International Court of Justice, which is really important. It's part of the UN Charter. An International Court of Justice is really about disputes between countries. So, and about a specific question of international law. But it's not really there to hold individuals to account for human rights violations. That's not part of the mandate of the court. We do have another court now, which is the International Criminal Court, which is very good, and that is about accountability, but it's only about accountability for war crimes, crimes against humanity, genocide, and now sort of the crime of aggression. So again, it's not really about the broader issue of human rights. So there's a vacuum here. There are processes within the UN for accountability of human rights, but they don't have that weight of legal process. And I say it's not just the weight of legal process. Legal process is not just about sort of standing up saying, hey, you're wrong, or you have to do this. Legal process is actually a facilitating process, because it provides like a neutral framework to bring in the facts and apply the law. So out of the judicial process, it often leads to negotiated settlements. because it provides a place for competing parties to sort of step down from the political rhetoric, step down from having to defend themselves against the other side, and come in more as what are the facts here? What is the law? And that often ends up with a really interesting process of finding solutions. And that's one of the reasons why, if you have a look at the decisions from the International Court of Justice, over 80% of them are implemented, accepted by both sides, and implemented. Not always straight away, but they're implemented. And this is quite a phenomenal success rate for resolving disputes. And again, that's another reason why I say if there is a gap, which there is, in the international judicial system on human rights, would a World Court of Human Rights provide something positive, or would it just be ignored? And the experience from the other courts we have is that they're not perfect. None of them are perfect. None of them are 100%, but they're so much better than having nothing, so much better than a vacuum. They provide so much more capacity for bringing accountability, for applying the law, for reining in grossly illegal behavior, and providing frameworks for resolving conflicts. So sorry, that's quite a big introduction, but I'm sort of connecting some of the dots from where I started as a non-lawyer, seeing the value of law, and then being able to be engaged in legal process, knowing that I come in more as the political campaigner. How do we get these cases up and running? How do we get engagement in them? The lawyers will need to come in with the law. The scientists or others, researchers, need to come in with the facts. That's very important. And then all that's laid out, for the judges, then to do their process of evaluating the facts, applying the law, and then reaching conclusions. So, sorry, that was a long answer, but I think I covered more than just your first question there, David.
Definitely, Alyn. Thank you. That was all really wonderful synopsis of everything we're trying to do to explain the importance of having a World Court of Human Rights because there's so many people out in the legal field who may not understand why it's so important, why the law, from your personal experience, you've seen law in action is much better than a vacuum where you can't implement or challenge what's happening in the world that's either whether it's violating rights or harming the environment or producing situations of war. It looks like Dr. Chobo actually has a question already. I do want to get Alyn to give you a chance to go in to explain how, especially because the big focus has been the International Court of Justice, how that relates to the Law Not War campaign. And then there's a few other campaigns that I know that you're really deeply involved in. I want to hear about that and how we can get involved. But I would like Dr. Chobo, if you would like to go ahead with your question, because it may relate to what you were just saying. So go ahead, Dr. Chobo.
Thank you, David. Thank you, Alyn, for this amazing explanation. My question is this. What is your best approach to deter powerful countries from using nuclear weapons when it comes to geopolitical conflict? But by the way, thank you for raising a World Court for Human Rights in your approach. That's very important. But the issue or problem we are facing right now in our advocacy is to explain to political leaders that this court, the establishment of this court, is not against them, but it's for them. Because most of them they're afraid of outcoming of this court. Thank you.
So, in addressing your question, how can one deter a nuclear weapon state from using nuclear weapons? There's no one answer to this. There's a range of factors that are involved in this. I will bring in some of these, and depending on where you're sitting in the world, different things will have more relevance than others, because the role of nuclear weapons within the security policies of each of the nuclear armed states is not the same. They vary to some degree. Some of them really will hold them for pure deterrence, to prevent another country from attacking them. But others, the nuclear weapons are also there for coercion, We've seen that, for example, with the Russian invasion of Ukraine, and President Putin making announcements, watch out, Europe, don't support, or the rest of the world, don't support Ukraine, I've got nuclear weapons. Or when he annexed, territory within Ukraine, he made this threat again. This is now part of Russia. We defend Russia with nuclear weapons. Watch out. So these are coercive threats. That's not really like defensive threats. There's also other aspects to it. The role of nuclear weapons, for example, for North Korea. North Korea is a very different political situation to the United States. India is in a very different situation to France. So the role of nuclear weapons is not exactly the same. So I'll mention a few things for deterrence, but they'll apply in different ways to different ones. So first one is that strengthening the norm against any use of nuclear weapons, strengthen the norm and the law against any use of nuclear weapons can help deter the use of nuclear weapons. So some have said there's a bit of a taboo against the use of nuclear weapons. Now, and I think that's true. So a taboo is a bit of a norm, a bit of a law. What's contributed to that? One thing that's contributed to that is very strong civil society campaigns, from the 1960s, saying this is what would happen if there's a nuclear war, doing all sorts of things, like movies like The Day After and various others. Lot of education. That education is not just about people, it was also education about policymakers and leaders, saying it would be a disaster if nuclear weapons were used. So you have to ensure that they're not. Now, in the beginning, this wasn't really resonating very much with the leaders during the Cold War, because this Cold War framework was such a powerful thing, it sort of took over from most others. But at the end of the Cold War, that shifted considerably. And the seeds were already sowed when Gorbachev and Reagan met in Reykjavik and said, no one can win a nuclear war, so a nuclear war must never be fought. So you can see already at the end of the Cold War, there was start of this notion in the leaders of a norm against the use of nuclear weapons. And this has been consolidated. It's been strengthened by the series of conferences on the humanitarian consequences of nuclear weapons, and specifically International Court of Justice case, 95-96, the one that I was involved in taking. That International Court of Justice case, the conclusion from the judges was applying existing law, the laws of warfare, which all of the states accept that they are subject to the laws of warfare. In the US, it's written to the military law manuals. They don't say the law does not apply to us. Up until the court case, they've been saying, yeah, but the law doesn't really apply to nuclear weapons. Well, the court said, no, it does. It applies totally to nuclear weapons. And this is what it implies, that the threat or use of nuclear weapons would be generally illegal. The court couldn't find an actual legal use. They said there may be in this extreme circumstance when the very survival of the state is at stake, but even then international humanitarian law still applies. Now, we've seen this play out now in that 2 years after the decision from the court, Russia adopted a new strategic doctrine, which actually used language from the decision from the court, saying that the policy of Russia is only to threaten or use nuclear weapons when the survival of Russia is at stake. That sort of still has held sway to some degree. When Putin has been making his threats, often the foreign minister, Lavrov, has sort of come up and said, well, actually, we're restrained in our threat or use, by this doctrine, which comes pretty much from the decision from the International Court of Justice. But I say not by the decision alone, it's also because of the awareness of what might happen if they launch a nuclear war. It's like it could end in disaster. If Russia decided to use nuclear weapons in Ukraine, they could get hit back with nuclear weapons or get attacked with conventional weapons. There's a sort of like it's crossing a red line. So that's a self-deterrence as well. So there's a few factors in there that are preventing, to some degree, the use of nuclear weapons, but it's not, you can't have full confidence in that. That could break down in a conflict situation when you have still the deterrence policy, right, to threaten the use, to deter someone else, and you may actually push that forward. They may push forward. They've got first strike options. If one side thinks the other side is about to launch a nuclear strike, they might strike first to take out. There's also possibilities of mistaking incoming missiles or some other incident as an incoming missile and launched by accident. So there's miscalculation, there could be accident, there could be escalation and crisis. So we're not safe. We do need to shift the policies. We do need to work towards the phasing out the reliance on nuclear deterrence. While nuclear deterrence is still a policy, we have that risk. So what we're looking at in reducing the risk of nuclear war is first, consolidate the norm against use. Make that a strong law, get UN declarations on that. But more than that is to phase out this idea that you need nuclear weapons to provide for your security. That there are better ways to meet the security issues, including threats of aggression, than threatening with nuclear weapons. And so that includes enhancing the use of the UN General Assembly in cases of aggression, the International Criminal Court in cases of aggression, the International Court of Justice. They're not perfect yet, so it's hard to sort of convince everybody that they could give up nuclear deterrence now. But as we build, these other mechanisms for providing security without relying on the threat or use of force, we can build more confidence to give up the reliance on nuclear weapons. So it's quite a long answer, but it's one indicating that the building of the courts, where it's the building of the governance mechanisms, strengthening the UN General Assembly, for example, getting rid of, if you can, phasing out the veto power of the Security Council, are all part of the process that could lead to a lowering of the role of nuclear weapons, more confidence in law, not war, and so therefore being able to move towards the elimination of nuclear weapons. And what the specific call of law, not war, is to call for every country to accept the jurisdiction of the International Court of Justice. That's the most important, because the threat of use of nuclear weapons comes from these disputes between countries and the concern about aggression from other countries. So if you've got every country accepting the jurisdiction of the International Court of Justice, and there's a dispute between Ukraine and Russia, for example, they don't have to build up their weapons. They don't have to threaten each other or attack to try and get their interests met. They take it to the court, and it could be resolved through the court. So that's the vision. And of course, we're not going to get it tomorrow, but we're putting forward saying why maybe we can sort of look to getting universal acceptance of the jurisdiction of the International Court of Justice by 2045. Very idealistic ambition, but it gives people hope that we can move forward. And we're seeing now, more than ever before, people turning to the International Court of Justice as they haven't in the past, seeing that when diplomacy breaks down, the court is so important. So there's more cases in the court now than at any other period in history. Doesn't mean they're all going to be successful. There are some that have got real big problems. It also doesn't mean that all the cases in the court can fully deal with the situation, because we don't yet have universal jurisdiction. So some of the cases in the court can only look at a certain part of the problem. They can look at, for example, is one country committing genocide or not, because under the Genocide Convention, you can take a country to the court. But that's not the full problem. There's a much bigger problem. And if you can't get that bigger problem in the court, then you're still going to have armed conflict. You may just sort of restrain it a little bit. So that's why we need universal acceptance of the jurisdiction of the court, because then you can ensure that when you take a case to the court, it can deal with all of the issues in that conflict, not just whether one country is violating the Genocide Convention or violating the Convention on the Law of the Sea, which is limited. Everything that's involved, everything that's important to this particular conflict could be addressed. And the fact, when countries have accepted that jurisdiction and taken the conflicts to the court on this, it's been really successful. Libya and Chad, had fought 3 battles over the Azure Strip, the resource strip. After they took it to the court found in favor of Chad. Libya accepted that, pulled their troops out of the area, and signed a peace agreement. That's just one example. There are many other examples of the court working to be able to resolve these conflicts.
Thanks, Alan. Yeah, I mean, it highlights the point that within countries, when there's a dispute, those entities, whether it's like Colorado and Kansas fighting over water rights, they go to the court and they don't fight each other. They don't pick up arms and militias and start fighting each other generally, unless there's a civil war, but generally that hopefully that doesn't happen in a democracy. And so why can't we have this same idea of having a court, common world law for all of humanity? So we stop the reasons for having wars because our disputes are taken to courts. Yeah.
Also, you have to have confidence that the court is fair. So it's not just a matter of having the court, it's having to ensure that it's got a fair process. And the International Court of Justice is pretty good. It's not perfect. They have 15 judges there. The judges are appointed by both the General Assembly and the Security Council. Neither one can veto the other. So the Security Council can't veto, but they have to sort of come to some agreement. It's not perfect, but it's pretty good. And we see that in the quality of the judges that get to the International Court of Justice. The ICC, International Criminal Court, has a different process. It was set up not by the UN Charter, but by a treaty. They've had a couple of little niggles, but they're also doing very well in terms of the accountability of the judges. So we see that we've got good experience. And the same with the International Tribunal Law of the Sea, very, very accountable, the judges, and that's part of the reason that the decisions are respected, because people feel if they feel that they're getting a fair hearing, it's fair, it may not go their way, but if it's fair and the process is fair, then it's much easier to accept that, whether that's as an individual or whether that's as a country. So that's an important part. And I think that's, as I said, one of the reasons why these international courts work, because they are well respected. They have pretty good process.
Excellent. Well, so before we go on to where you can tell us more about what you're doing specifically with Law Not War and the Impact Coalition and maybe some of the future, there's a question also that relates to some of your initial comments about New Zealand from Alex in the chat. And he said, he was getting the feeling that the power maybe was less from the ICJ, but the power of the New Zealand public, who said, we don't want nuclear weapons. So what do you think? Do you think that verdict came about because of the power of public opinion, or was it really some independent power of the ICJ, or maybe a combination?
If he's talking about the 1974 International Court of Justice case on French nuclear testing, no, that the judges are looking at that on the basis of law, not very little attention to the public opinion side. The court, I'll come to that in a moment, and similarly, with the follow-up, the underground testing, again, the court ended up actually not giving a decision on that, because with France pulling out, they couldn't get the jurisdiction, but France stopped the testing anyway. But if you're having a look at the process, of the court, what attention the court gives to public opinion, it's not a huge amount, but it's not nothing. And there is why they feel that they've got some capacity to look at public opinion is through the Demartens Clause in the Hague and Geneva Conventions. And I'll mention this. So we start with the Hague Conventions because they were the first ones. 1899 was the first one. And what they were doing was sort of looking at various weapon systems and methods of warfare. So it's looking at international humanitarian law and what is prohibited, because it might be inhumane, like cause unnecessary suffering to combatants, suffering that will last a long time after the conflict is over, or affect non-combatants, so be indiscriminate, or impact on neutral territories, countries that aren't involved in the fight, or cause long-term and severe damage to the environment. These are the key principles that they're applying. So what they were looking at in 1899 was, which weapon systems, do we need to ban? And they go, use of poisonous gases. So that was prohibited in 1899. Dum-dum bullets is another one. Bullets which go into the body and then expand, leaving bits of material, in the soldiers' bodies, which last long time after the conflicts, like cause, damage that's not related specifically to ending the conflict. So they were banned. But then and this was because Friedrich de Martens put this forward, who was actually in the Russian Foreign Ministry, said, but there's going to be weapon systems which will be built. There are new inventions come along all the time. There's going to be new methods of warfare that we can't know about right now. What can we say about them? What can we say about the future? So they came up with the demands clause, which was that when there is a case, of a weapon system which is not covered by the existing regulations, the principles of humanity and the dictates of public conscience shall apply. So this reference to the dictates of public conscience was basically saying, when you're coming to look at what is inhumane, it's not just lawyers who should be deciding that. You should be reflecting what is a strong, perspective in society of what is inhumane. And that's where the dictates of public conscience comes from. So it's not quite public opinion. It's more sort of public perception about a specific aspect that's relevant to this case. And we utilize this in the nuclear weapons case because nuclear weapons weren't around, when the Hague Conventions, and the Geneva Conventions were negotiated. But according to the demands clause, this still applies to these weapons. And the dictates of public conscience have some bearing on this. So we gathered, I think it was like about 6 million individually signed dictates of public conscience, which is not the same as a petition. It's basically, you can't just go and say, hey, can you sign this saying you're against nuclear weapons? Basically, it was a whole education talking to people about what is international humanitarian law. This is what it was banning back then. We believe this applies to nuclear weapons. What do you think? Do you think that applies to nuclear weapons? And if so, why? And so it was a whole process of getting people to sign a declaration of public conscience. It wasn't just a simple petition. And the court paid attention to that. We delivered boxes and boxes of them to the court. The media paid attention also. So there is something to do that. But that's, as I said, that's not quite public opinion. It's more sort of a demonstration of what public perception over a legal issue is, and the inhumanity or humanity of a particular practice.
I see.
Was that sort of answering the question?
I think that would get to the answer to Alex's question. Robin also put a question in the chat saying, even when countries sign up to ratify or sign up to the ICJ as UN member states, they tend to pick and choose what judgments they follow. How do we make judgments binding on ratifiers or signatories to the UN Charter or parties to the ICJ?
So what the process is that a country can make a declaration saying that it will accept the compulsory jurisdiction of the court for any cases with other countries who've also accepted that jurisdiction. So that's the declarations. There's 74 countries have made those declarations. So that gives the basis for launching the main basis for launching a contentious case for one country to take another country to the court. That's the best approach. As I said, in that approach, if you've got a dispute, you can bring up anything relating to that dispute and any law that might be applicable. So that's the best approach. The second approach is where a country may not have accepted the jurisdiction of the court for any dispute between them and other countries that accepted the court, but they've signed on to a treaty, and in that treaty there's a reference that if there is a dispute that is not resolved through other mechanisms within the treaty, either of the party could launch a case in the International Court of Justice. So, for example, the Genocide Convention has that. So does the Convention on the Elimination of All Forms of Racial Discrimination. So if there is a dispute under that treaty, one country can take the other country to court, but only on the violation of obligations under that treaty. So we've seen, as I said, a few cases now based on that. The Gambia has taken Myanmar, on genocide, based on the Genocide Convention. Ukraine has taken Russia, to it on the Genocide Convention. and we have South Africa has launched a case against Israel under the Genocide Convention. So this is the way of getting there. Now, in any of those, when you take a contentious case, basically the decision is legally binding. I think what the questioner may have been asking is maybe legally binding, but who's going to enforce it? And that the court doesn't have an enforcement body itself. The enforcement body in the UN system is the Security Council, and it is supposed to enforce the law to ensure that countries are. But there's problems with the Security Council. There's 5 countries there that have veto power. So when you get a decision from the court that's relating to one of those countries, Nicaragua versus the United States, for example, 1982-83, United States was supporting armed revolutionaries to try and overthrow the Nicaraguan government. The International Court of Justice found in favor of Nicaragua. The Security Council didn't do anything to enforce that decision because the United States vetoed it in the Security Council. So there was an enforcement body. But that's not the most important thing of whether or not there's an enforcement body. The most important thing is whether the decision is accepted and implemented by the disputing parties. And the overwhelming majority of cases, that is the case. Not always straight away. In the case of Nicaragua versus the United States, in the beginning, this was under the Reagan administration, they said, we're not going to abide by the court. There was pressure from the Congress, the US Congress, said to which was the majority was Democrats then, were saying, well, we're not going to fund US weapons going to Nicaragua. The administration then sent them through the CIA, through other secretive methods and stuff. So the government, in the beginning, they didn't go along with it. But actually, after a few years, they did. It wasn't straight away. There was additional court cases run in the United States to pressure the government. But what happened also, and I think this was part of the reason why the United States ended up accepting this, was because that court case, Nicaragua versus United States, actually initiated a peace diplomatic process in Central America. Oscar Arias, the president of Costa Rica, could refer to the decision from the International Court of Justice, which was saying, these are the laws with regards to the use of force, between US and Nicaragua. There are these treaties there. There's also some regional treaties. And so what Oscar Arias did, following the decision, he called the leaders of the Central American countries, to San Jose and Costa Rica and negotiated the Central American peace accords. It took a little while. It wasn't just one sitting. It took a bit. But it was because of the decision from the court that he could get the leaders to agree, because they were having civil wars in these countries. With sometimes the revolutionaries were being supported by Soviet Union, and the government was being supported by, we're talking, Guatemala, Honduras, El Salvador. And those of you in the United States will remember these were civil wars and part of the Cold War conflict. The International Court of Justice decision gave a context for resolving that, for bringing peace to Central America through law, not only because it gave a mandate for Oscar Arias to bring the leaders to negotiate, but it also meant that he could get support from Europe. Prior to that, Europe was on the Western side, so it was always backing the United States. But when the court came down with its decision, the European countries go, well, we're in favor of international law. This is the courts lay down, that there has to, that peace is the law there. And so that then meant that the Central American peace accords were supported first by Europe, and it meant that it was really difficult for the United States to oppose them. So it doesn't always happen, as I said, immediately. It doesn't always happen willingly, but there's so often the decisions from the court provides political process that helps then bring a resolution to those issues, and it differs in each situation. They're not all the same. So I think that's the answer to the question. We're not going to succeed in trying to build a new enforcement body for the International Court of Justice, but we don't need to. The decisions are so important; they carry so much weight, they give so much possibility for political process that it's incredibly effective as it is. Of course, it'll be more effective if we can get universal acceptance of jurisdiction. But we don't need to say, oh, we can't go to the International Court of Justice because it doesn't have enforcement body. That argument is just meaningless. You go to the International Court of Justice because it can actually make a difference.
Right. Now, I know that the Law, Not War campaign is really about getting universal jurisdiction, and you've already talked a lot about that. There are a few more questions in the chat, so I'll call on Mark and Evan to ask their questions. But I do want to say, hopefully you can stay a little bit past 12, just a tiny, or one, I mean, just to talk to us more, because I do want to hear about how the Impact Coalition for Justice Institutions, some of the future, how we can, imbue those campaigns or projects with this idea of creating a World Court of Human Rights and what you've learned from your coalition building. So I want to get back to that before we end. But I guess Mark, Mark, Evan, and Zalanda have questions or comments. So Mark, you are up first.
Thank you, David. And Alyn, thank you so much for coming and giving us hope. You're essentially preaching to the choir, about the possibility and the benefits and the value of supranational courts. David started the conversation this morning with the announcement that we may be on the brink of getting access to the United Nations. As we envision this next phase of our efforts, we literally envision trying to interest nation-state representations in what I call teeing up the Treaty of Lucknow, the Statute of the World Court of Human Rights, for consideration by the UN in the appropriate committee, sixth, third, whatever venue. Can you give us any recommendations as to which member states of the United Nations may be amenable to advancing the cause of such a court?
I can only give supposition. I can't say, hey, they will definitely come on board. But you see, there is a number of countries, which we will call like-minded countries, that are supporting a number of these similar initiatives. So a group of like-minded countries, which includes New Zealand, Switzerland, Netherlands, Mexico, Costa Rica, Romania. There's a couple I'm forgetting here. Have been building support for the idea of universal jurisdiction, the International Court of Justice. Oh, Liechtenstein, of course, is one of the other ones there. Generally, it's a similar grouping of countries. There's more, and we can bring in more sort of later on, but there's also a similar grouping of countries that were supporting the Liechtenstein initiative in the UN General Assembly. For example, when a member of the Security Council casts a veto, particularly with regards to armed conflict or active aggression or serious violation of human rights or atrocities, there is now a process that they have to take this to the General Assembly, explain why they're doing the veto, and the General Assembly can then respond. And the General Assembly has responded with regards to the Russian invasion of Ukraine. Even though Russia would veto anything in the Security Council, the UN General Assembly has moved ahead and declared this an illegal act and taken other measures as well. So these countries that are involved in those processes, there's more also the ones who are leading on the UN Summit of the Future. So there's also like Germany, Namibia, a couple more. You'll see them popping up sort of quite often. The Gambia is another one over from Africa. Some more will come in mind at some stage, but it's quite handy if you're wanting to get open the door with some of these countries. You look at something else similar that they've done, and you say like Liechtenstein, for example. When you contact them, say, we thank you so much for the initiative that you took, on the UN General Assembly initiative. We'd love to talk to you about something that's relevant to this, to sort of, or complementary to this. This sort of one, it helps you get a foot in the door. But also it's really important, to appreciate the good things that some governments are doing. Often, people in government or policymakers get so much criticism. People saying you're not doing this, you're not doing that, you're doing that wrong. When there's good stuff coming forward, it's really good to recognize this and affirm that. That helps give you a really good basis for then saying, now let's do more.
Thank you.
Okay, so Alyn, Evan has a question, which I'll ask him to ask if you'd like, about public perception and civil society power And Zalanda has a question about gender apartheid and how the ICJ may be breaching women's rights due to that. So, Evan, why don't you go ahead?
Yeah, thank you. And thank you, Alyn, for your wonderful account of how you have leveraged international law and opinion. What I'm asking it, we talked a lot about today about popular opinion as opposed to the legal findings of the court. I'm a follower, by the way, of George Lakoff, who holds that the framing of an issue is everything as to determining the outcome in many cases in politics. So my question to you is, what are the civil society channels by which the International Court of Justice influences public perceptions and framing of issues and disputes? From your perspective.
If I understand the question, I respond firstly from the side of the International Court of Justice. They have a particular role to play. So with a case, they have to look at what is the evidence, what is the application of the law, and then what are the responsibilities of the states resulting from the application of the law to the facts, to the evidence. That's their role. Their role isn't to shape that for public opinion, but it is important that they are clear and understandable in that, so that their decisions are understandable not just by lawyers and by the governments involved, but by the public as well. So what the International Court of Justice does for this is a few things. One, you now can watch the public hearings, and all of the decisions, including the procedural decisions, interim measures, and the outcomes of the court are all available really quickly on the website of the International Court of Justice. And both the provisional measures, which happens before you conclude the full case, and the full decision, which is often many pages. What they also do is they always have a summary of that in like a press release, so that those who don't want to go into all the details of the law, or don't understand all the details of the law, they can still understand it from the summary that the court puts out. So I'd say that's what the court can do in order to ensure that there's a clear understanding of what they're doing, what the case is, what the outcomes are, what are the responsibilities of states in that. With regards to framing the narrative, that's not the role of the court. That's the role of us in civil society. Where there is an incorrect narrative on the court, we can refer to the facts of the court. When there is an incorrect narrative that the court is not very useful because it doesn't have an enforcement power, so therefore no one implements it, we can give them the facts. No, actually, over 80% of the decisions are accepted and implemented by all parties. So we can respond to false narratives with information about what actually happens with the cases. That's part of the Law Not War program, therefore it's educating people about previous cases, what's happened, what have been the results, how it's actually had an incredibly, in most cases, a positive impact, and that then can help people understand, the value and the role of the court. That's what we can do as civil society. The court can't do that. They can only make the decisions and the process as clear as possible, but it's us that have to then educate those who have misconceptions about the court. And there's various ways we do that through our webinars, through videos, through having events, at different, taking the court out to the people, so we go to many different conferences and put side events and panels, on Law Not War. We go to the Interparliamentary Union where there's 180 member parliaments from around the world, so that legislators get to understand a bit better, what the court is. So yeah, that's our role, to educate and shape the public narrative on it.
Excellent. Thanks, Alyn. Well, so Zalanda, you have the last question or issue. If you'd like to bring that up, please, for Alyn.
Thank you, David. That's wonderful, Alyn, for the informative information and exactly at the right time. So my question is regarding the women's right and also gender apartheid. Is there any procedures with the ICJ and also General Assembly for coding and bringing those states that are committing the gender apartheid for the specific genders like women and girls? And what would be the solution for this to make a statement for that with the ICJ? Thank you.
Yes, and my answer to this is it doesn't just rest with the International Court of Justice. There is a range of mechanisms within the United Nations in order to be able to take these issues forward. One of those is the International Court of Justice, and that can be done under international law that's with regards to the rights of women. So the International Convention, CEDAW, is the Convention on the Elimination of Discrimination Against Women. Now, so CEDAW, that's a convention, and the obligations of that can be brought into cases, but that's not all. There's more than that. So I'll say, firstly, there's more law than just CEDAW, the Convention on the Elimination of Discrimination Against Women. There is more in terms of gender equity that has come through various other human rights bodies in the UN. That would probably be more what we'd say is part of customary law, because it's not sort of like in a convention, but it's often explanations of what is meant under various aspects in the convention. A lot of that happens in the Human Rights Council, and in the Human Rights Council, there's a process of challenging governments on their implementation of these obligations and protecting the rights of women. And so in the Human Rights Council, it's called the Universal Periodic Review process. That's the best one. There's also the Universal Periodic Review is on all human rights, but there's also a periodic review just under CEDAW. So there's a CEDAW review process. Each country comes up for review, like once every 5 to 6 years. Civil society can come and lodge questions. What are you doing here? Here are instances where you don't seem that your government's protecting the rights of women. And if the council, the Human Rights Council, if any of the members of the council themselves go, oh, that's a really important point, this civil society organizer is raising, we're gonna push the government on this, the government has to respond. Now, of course, again, there's no enforcement powers. So that response may be weak. It may not be, accurate. There's a lot of lying. There's a lot of whitewashing. We know there's a lot of words spoken in these things, and the reality is different. But the very fact that you've got an opportunity in this process to bring up this responsibility of the governments, I'm saying governments primarily, because that's the key ones who are violating the rights and have the obligations to protect them. That is important in the process, because you're providing a space where not only can civil society and impacted communities raise these in a safe environment, but also others are looking on. Other members, other countries are looking on. And while the government may feel, generally, oh, it's our decision what we do with women's rights in our country, they want to look good in the eyes of the other countries for trade reasons and for other reasons. So that's where it can actually have some impact. Again, not perfect. There's not an enforcement body that when violations of the rights of women come to the fore, they can send in, like a peacekeeping unit or anything. They can't really do that. But it is an important process that can make a difference. That's one part. There's also through the UN system itself. And this has been part of with that in UN, including like peacekeeping forces, for example. There have been real problems with some of the military units coming from some countries that have actually been very male and violating of the rights of women in some of the communities where the peacekeeping operations were. So there's been a whole review process of that within the UN to ensure that UN peacekeeping units are much better at protecting the rights of women. So there's a process within the UN there as well. So that's those two. Well, there's one more process, and that's in the International Criminal Court, But in the International Criminal Court, it's only a certain aspect of it. In the International Criminal Court, what they can deal with is the use of rape, as a war crime. So rape is now a war crime if it's used in the conduction of military operations. So that can actually become, and you can have prosecution through the International Criminal Court. But that's only one part of protection of women. Other parts the International Criminal Court couldn't look at. But if we swing back now to the topic of what this is about, if there is a World Court on Human Rights, there'll be a much greater opportunity. This would have a much stronger process than the Human Rights Council. Rights of women could be taken to the International Court of Human Rights. That would have an even stronger impact than what we're getting in the Human Rights Council. So it's another reason for supporting, the establishment of an International Court for Human Rights.
Thank you.
Yeah. Thank you, Alyn. So just two quick things, if you could stay on literally for maybe 3 more minutes. John had a follow-up question: could there be a government, or like Iceland, which has really good gender equity, or maybe like the World Health Organization, that could take an advisory opinion at the ICJ on gender apartheid? That was one follow-up from John. If you could maybe answer that in a minute. I don't know if that's possible. And then if you wouldn't mind seriously focusing your final comments on the Impact Coalition and some of the future, and how we can imbue those processes with this idea of a World Court of Human Rights, and maybe what you've learned from coalition building in that respect. Thanks.
Yeah. So John's raised the issue of an advisory opinion of the International Court of Justice, which is a really important process. This is also available in the International Tribunal of the Law of the Sea, for example, and in some other courts. And why this can be really important is because there may be some issues that are not about a dispute between two countries. They're about a more universal issue, like the threat or use of nuclear weapons. And that's why, we took an advisory opinion on that, rather than New Zealand just trying to take 1 or 2 countries to the court. This was a much better approach. Similarly with climate change. In order to build a cooperation on climate change, you can't just put one country against another. That's not going to work. It has to be done cooperatively in a forum which is going to put forward, this is the collective obligations, and states have to take forward these. So that's why there's an issue of climate changes in the International Court of Justice through an advisory opinion. And this is one of the most important cases in the court's history. So again, if there is issues with regards to women's rights that are transcending one country, they're like over more countries. So it's got a transnational sort of aspect to it. Definitely an advisory opinion can be a really good way of going. In order to get there, you have to get one of the organs of the United Nations that has authority to ask the question. You have to get a resolution through that body. So that includes the World Health Assembly. So the World Health Assembly could do that. ECOSOC could do it. The UNGA, General Assembly, can do it. The Security Council can do it. And so there would just be a question of which would be the best body to do that. When there's sort of like big issues, not sort of like just an administrative tribunal issue or something, but a big issue, and this would be, I'd say, would be of the nature of a big issue, like a universal importance, the UN General Assembly is generally the best body to go through, because one, they can't be blocked by veto power, which the Security Council can, but also under the advisory opinion process, it's really only the Security Council and the UN General Assembly that have the mandate to ask any legal question. The other UN bodies, they can only ask questions based on the mandate of that body. So it can restrict, the outcome, and particularly when these issues often have interconnections. They're not just relating to one part of the UN. And we saw this, for example, in the nuclear weapons case. We actually had 2 questions asked, one from the World Health Assembly. That was the first one. And the second one was from the General Assembly. And the court turned down the question asked from the World Health Assembly on, the legality of the use of nuclear weapons, considering the health effects. What the court said is the World Health Assembly doesn't have authority to look at the legal requirements. It really can only look at what are the medical aspects, and dealing with medical aspects of nuclear weapons, you don't really need to know what the law is. I thought it was a bit of a wishy-washy sort of response from the court. But I think, they sort of did that because they knew there was one question coming from the General Assembly, which they were going to answer. So it was sort of like, oh, we'll deal with the one we know we have to answer, and we'll just put the other one aside. But it's quite, that just shows, though, that if such a question like this, was asked through one of the other agencies of the UN, it could be more restrictive, and the court might turn it down if the question is going beyond the mandate of that particular UN body. But for the General Assembly, it generally doesn't turn down requests for advisory opinions. And sorry, there was a second question.
Well, so just to tell us how the Impact Coalition for Just Institutions and maybe some of the future, how we can imbue those processes with this idea of creating a court of universal jurisdiction like a World Court of Human Rights.
Yeah, okay. So I will put the link to the Impact Coalition on Just Institutions into the chat so that you can contact that if you want to know what is the program for that. So the Impact Coalition on Justice Institutions and the International Court of Justice is advancing the idea of the role of the judicial institutions. This is not just at the international level. It's also looking at regional level, and it's also looking at the interaction between the courts and tribunals at the international level and at national level. And most of this is based on a principle of subsidiarity. What subsidiarity means is that you deal at the issue at the lowest level that it's possible to deal with. So if it's a dispute between neighbors, for example, you don't go to the International Court of Justice. You go to sort of like, a neighborhood tribunal, or the mediation service of the city council, or other neighbors might even be able to help come in and mediate the conflict. You deal with it at the level that you can address the issue. And so these courts, the ones at the international level, are not imposing on the lower courts. They're actually taking up issues which can't be or aren't being addressed by the national courts, but there's an interaction between them. And so that's what this is working on. It's looking at the role of judicial process and at all levels, but with a strong focus at the international level, because that's where we have such big gaps at the moment. And there's a number of events that are happening during the Summit of the Future, but also a lot of preparation beforehand. And one of the things that was prepared beforehand, putting forward some of the ideas and proposals in this, was something called the People's Pact for the Future. This was facilitated through the Coalition for the UN We Need. And I will put in a link to the People's Pact for the Future so that you can have a look at it, because it's got a nice overview of the recommendations that are getting a lot of traction in civil society. I'm just pulling it up, the People's Pact for the Future. And then, as I said, the Coalition for the UN We Need is what has been facilitating that and providing places for consultation and engagement of people in preparation for the Summit of the Future. It's not the only one. The Impact Coalitions have sort of broadened it out and brought in more people. So if you want to be engaged, either join the Impact Coalition, or sign up to the consultation process through the Coalition for the UN We Need. Those would be my recommendations. Oh, the People's Pact for the Future has been put in. Thanks, John. And that's also C for the UN.
That's excellent.
There. Yep.
Well, what I would say, Alyn, thank you so much for all this time and for staying extra over the allotted time. I sincerely appreciate that. I would say, and I know Rebecca Shute does this from CGS when she gets a chance to mention the idea of a World Court of Human Rights when it relates to other future institutions. If you get a chance talking with individuals or groups, whether it's with the Impact Coalition or some of the future through the online events that you may be attending, please do so. And offline afterwards, if we can have a chance to chat, and maybe since we didn't have much time to do this today, but to chat, to learn about your suggestions in building our World Court of Human Rights Coalition. We need to learn from experts such as you. And once again, I thank you so much for your time today. Any final comments, Alyn?
No, but just we already are, talking about, by we, I mean the Just Institutions Impact Coalition is already talking about the World Court of Human Rights, along with a couple of other proposals, a proposal for an international anti-corruption court, and a proposal for an international court for the environment. Those other two are already in the platform of MEGA, Mobilizing the Earth Governments Alliance. And I think we might even be able to talk about, is there a possibility of raising it also through in the environmental side, because the connection between human rights and environmental protection is also very strong. Yes. So that's just something to flag. I think there are going to be we're already doing it through the Impact Coalition. There may be other opportunities also to advance this.
Excellent. Okay, Alyn, thanks again so much for your time. We really sincerely appreciate learning from you and hearing from your expertise over the many years, and look forward to continue to work with you in this process.
Thanks, David, and thanks to everybody who participated today. It's been a great pleasure.
Yeah, thank you so much. Thanks, everybody. And we'll be on September 25th, probably for our last Wednesday of September for our next meeting. Thanks again, everybody.
Thanks.
Bye. Thanks, Alyn, again. Take care. Bye-bye.